that every surety receives notice when a person misses court. I do want to caution, however, there has been some across the country, some legislation that has been written in response to bail funds. And in Louisiana, we have no legislation that controls that. In 2017, this body worked really hard to make sure bail reform was put into place and that we had guardrails to make sure that things were being done correctly. When it comes to these bail funds, we have none of that. And I do urge us, before we name this type of bail or release in our legislation, that we do look at it and we do write some legislation that puts guardrails on these types of funds.
I see. So, for example, Ms. Crawford, your group, they put up the cash bond. So if it's a $100,000 bond, the premium is what, would be what, 15,000, or is it 15% of the bond, or what?
So thank you for the question. We do the full cash bail amount, so we don't do a percentage, and our cap is about $5,000. In some instances, it may go up to about $10,000, but you're looking at $5,000 and below.
Okay, so
and it's the full cash amount.
So if there's a default on the bond, the entity to which it benefits gets the full amount.
Correct.
And so it's not just a percentage.
Correct.
So we don't really have to worry about the solvency of your type of company, but you're suggesting that there may be some groups that post a portion of the bond and that their solvency might be questioned later?
No, the cash bonds are paying the full cash bonds. If you look at the website, the Freedom Fund is described as a disruptor of criminal justice. Their person that are posting bonds are disruptors to the bail process. What I'm saying is, even in Georgia, they just passed a bill that says that they are limited on how many bonds a cash depositor. When the bail laws were written, a cash depositor was mom, dad, preacher. Now we have organized cash depositors that are taking money, using it for bail. When it is returned, there's no rules on how that gets returned in our state. So it can go, it's being put it in a person's name, it has to go back. And we want to make sure that there are some guardrails that we have.
So it goes back to the group that put it up, or you're suggesting it should go back to the accused?
A cash bond is a person pays a cash bond. I know in some jails they are allowing the same process as if mom comes in, the Freedom Fund comes in and does the bond in the exact same way. And on top of that, mom's already getting subpoenas. Mom's already getting notices of warrants. So there's not a line item that says organized cash depositors have any rights, because there's no legislation that protects the community or our criminal justice system from these organized cash depositors.
I think I understand what you're getting at, and look, that's for a different day, because this bill does not deal with that. And honestly, just off the top of my head, I'm not sure you can stop a group from deciding we're going to get together and put up money for people if they choose to. I don't know how you could stop that. It might run into some constitutional issues.
Georgia's did, and it passed.
Right, but I bet it's been challenged, but you know,
and it won.
But I'd be interested. But that's a story for a different day, because that's not the bill before us. But thank you for your testimony. Are there any questions of any of the witnesses at this point? The board is clear. We have no cards in opposition. We have Ms. Annette Fontana, Louisiana Clerk.